My name is Laura Lee, and with me is Sarah Goldfarb, and we are appellate attorneys with the Gardiner ad litem program. This morning, we're going to talk a little bit about the McKey and Gardiner scholarships. Specifically, I'm pushing buttons and didn't know it. Specifically, how you might use either of those as a tool for working with your dependent child with disabilities. Now, if I can. Maybe I'll give this back to Sarah because she knows what she's doing. Okay. By way of background, though, how many of you have heard of the McKey or Gardiner scholarships prior to seeing the presentations? Great. Okay. How many of those of you? How many of you have actually worked with either or both of those programs? Terrific. We've got a lot of experts then. So hopefully we'll learn from each other this morning. To put all of this in context, Florida has a strong public policy for improving educational results for children with disabilities. We have high expectations for all children, including children with disabilities, and we want to ensure that they have access to the general education curriculum to the maximum extent possible. That includes an appropriate exceptional student education with related services and aids in the least restrictive environment. Now, to facilitate those goals, it's necessary to have a trained, interested, and consistent educational decision maker. Ideally, in an ideal world, that would be the child's biological parents. However, in the dependency system, that might look a little different. So when a dependent child has or is suspected of having a disability, and that's defined by statute to include an intellectual disability, autism spectrum disorder, a speech or language impairment, an orthopedic impairment, a health impairment, visual impairment, or developmental delays. If the dependent child has or is suspected of having any of those disabilities, the dependency court must appoint a surrogate parent under Chapter 39 if the parent cannot be located. So sorry. You need to keep me away from technology. There we are, okay. Or, so if the parent can't be located, or the court determines that there's no person who has the authority, willingness, or ability to make educational decisions for the child. There's also a concurrent duty of the school district superintendent if a surrogate parent has not been appointed and one is necessary. By way of cross-reference, the Individuals with Disabilities Act, the federal law, specifically defines an educational decision maker as the parent, foster parent, guardian, caregiver, or the court-appointed surrogate parent. Okay, so what is a surrogate parent? That is an individual appointed by the court to act in the place of the parent for the purpose of educational decision-making and to safeguard the child's rights under the Individuals with Disabilities Education Act. Just briefly, I just want to note here, because Sarah will go into it in a little more detail, but one of the potential pitfalls of the McKey Scholarship or the Gardiner Scholarship that Sarah will talk about if you use the private school option is the language in the statute says if there's parental placement in a private school, that triggers a relinquishment of many, if not all, of the child's rights under the IDEA. So that's something to be aware of when you're looking at these scholarships. Okay, so what does a surrogate parent, who qualifies as a surrogate parent? They have to be at least 18 years old. They cannot have any personal or professional conflict of interest with the child, and they cannot be an employee of the Department of Education, the local school district, the Department of Children and Families, the community-based care provider, or a therapeutic foster parent. However, the child's own foster parent or caregiver or other parental substitute may be appointed as a surrogate parent in their personal capacity. Okay, the surrogate parent should also be willing, of course, to serve in that capacity, and also be knowledgeable about both the child, and ideally be known to the child, and also be knowledgeable about the exceptional student education process. As you'll see if you're not familiar, and as you already know if you are familiar, there are many facets of the McKey and Gardiner scholarship programs to be explored and analyzed in light of each child's unique needs and circumstances at the time. So a team approach is critical. The surrogate parent has to be willing to work with the child's caregivers, the case management team, the guardian ad litem program, service providers and the parents to the extent that that's possible or warranted. Under Chapter 39, the Department of Children and Families is required to provide training for surrogate parents. So, yes?
In the odd case where he's aged out, they're 19 or something, he's
Mm-hmm.
in high school, and don't agree or don't want a surrogate parent, can the child serve as their own advocate? Not that it's an ideal situation.
I would think that since they're, oh, yes, thank you. Anybody jump in, but I would think that if they're of the age of majority, they would have that right. Depending on the disability. Pardon? Oh, okay.
Sorry, just to repeat the question, I was asking in the odd case where a child has attained the age of 18 or 19 and they are refusing to have a surrogate parent, and I was asking if they were able to advocate on their own behalf. Not that this is an ideal situation, but does the statute contemplate that or case law?
I do not believe the statute actually addresses that. Again, I would think if, since they've reached the age of majority, that they could, but I think an audience member has some expertise that I don't.
Once they reach the age of majority, they're vested with their rights, and they are their educational decision maker. The team still needs to be there to support them if they need help. That would only be superseded if there is a guardian advocate in place or a guardianship in place. Okay?
Thank you, Alicia.
With
Good.
those specific rights in the letters of guardianship.
Okay. You should also be aware that the child's court-appointed guardian ad litem has to first be considered for the role of parent surrogate. They don't have to be, chosen, but they have to be considered. Okay, so let's delve into a little bit what the McKey Scholarship is. The official name is the John M. McKey Scholarship for Students with Disabilities Program. It basically allows the parent, foster parent, or surrogate parent to choose either a different public school from the one the child is actually assigned to, or a private school based on the child's needs. McKey is basically about matching funds. So what it does is takes the cost of providing the education, including the necessary services to a child with disabilities at their assigned school, and allows you to take that money and transfer it to either another public school, which can either be in the same school district or in an adjacent school district, or to transfer those funds to a private school. The private school can be religious or non-religious, but it has to be McKey eligible. There are certain requirements a private school has to meet and things they have to do to qualify to be considered a McKey school. The Department of Education website has a link to the list of participating McKey private schools. I also do want to note at this point, there is a pending challenge to the constitutionality of the McKey Scholarship Program. The trial court in Leon County upheld a challenge to the constitutionality, but it's currently pending before the First District Court of Appeal. So just something to kind of keep in the back of your mind. Okay, so who is eligible for a McKey Scholarship? A student in kindergarten through 12th grade who has either an IEP or a Section 504 plan for more than 6 months, so it can't be a temporary 504 plan. But they have either of those, and they've been enrolled in a Florida public school and reported for funding during the preceding October and February FTE surveys. However, that requirement, the prior enrollment, can be waived for foster children. And when we go through the application process, there's a specific link that you would click on to do that. So what are the benefits of the McKey Scholarship? Okay, as I said, the educational decision maker can choose a different public school than the one the child would be assigned to, or a private school. If they choose the private school option, the benefit would be either the actual tuition at the chosen private school or the cost of the assigned public school, whichever is less. In the last school year, the average scholarship awarded for a student with an IEP was just a little over $7,900, and for a child with a 504 plan, it was just a little over $4,500. So that's a pretty big discrepancy, and if you're not familiar with the program, you may be wondering why that is. And it's because the assigned public school cost is calculated on a matrix that's based on the services needed based on the child's IEP or 504 plan. So just briefly, we'll look at the matrix. There's a very long handbook on the matrix on the Department of Education's website if you're interested in looking at it. But basically the matrix has 5 domains of service types that would include the child's needs regarding the curriculum and learning environment, their social emotional behavior, their independent functioning, their healthcare needs, and their communication abilities. So you've got those 5 domains, and then within each of those domains, they're rated on the nature and intensity of the services required. So 1 would be no intervention at all is needed, and a 5 would be there's substantial modification required. For McKey students, this matrix is submitted only 1 time, and its rating is not subject to change. The school district can change it only to correct a technical or typographical or literally a calculation, we added this wrong error. And that's all the Department of Education can order a school district to do, is change that type of typographical or calculation error. So the matrix calculation is really important under McKey. The person or people who complete the matrix, it does not have to be the full IEP team. It can be 1 person as long as that person is trained in doing the matrix. So, and a parent's involvement in the matrix calculation is at the school district's discretion. So we would encourage you, if you're looking at this and getting involved in it, to really advocate for that educational decision maker to be at that matrix calculation. Although the statute provides for a reevaluation for the children every 3 years at the parent's request, that reevaluation, while it would be helpful in identifying, the actual services that may have changed, what the child needs, it won't change the matrix or the McKey scholarship amount. So it's really important that that's done correctly. You should also know that in terms of the matrix, we've cited a case here. There's no right to a due process hearing because it's just very limited what can be done about the matrix, like I said, just to correct the typos or the calculation errors. So it's really important to make sure it's done right from the beginning. Okay, so now you've looked at McKey a little bit. You think, maybe this would work. My child's eligible. What would I do to apply? So the overview of the application process would first to be to file a notice of intent, and then watch for your email determining eligibility or ineligibility. The department has to do that within 30 days. In the meantime, you should be looking at whether or not you would like to use the public or private school option, and that might require a lot of legwork and investigation. Go ahead and get the student enrolled in the school of your choice. And then the last I just put here so that we'll talk about it later, but so you're aware that the scholarship payments are made to the parent, and the parent has to restrictively endorse those payments over to the private school. So now let's look specifically at the first step, the notice of intent. This is done online at the floridaschoolchoice.org website, and we've just included the links. It's just scroll down through the links, the McKey Scholarship link, Parents button, apply for the McKey Scholarship. And then, as I mentioned earlier, there is a separate link for a foster child who doesn't meet that requirement of having been enrolled in the Florida Public School the prior year. So that can be waived, and there's a separate link for that. The school district has 30 days to determine eligibility. And once the notice of intent is filed online, there will be an immediate confirmation email with a confirmation number. Of course, you should hang on to that. And they'll also give you a notice of potential eligibility or ineligibility. And according to the gentleman I spoke with at the school choice hotline, they'll also, if any red flags pop up, if they might need more information or anything like that, they'll alert you to something that you need to pursue further in order to get this eligibility determination. The notice of intent can be completed by the surrogate parent, the foster parent, even a case manager. Again, talking with the gentleman at the school choice hotline, case managers are kind of leery about being the ones to actually go online and do the application because there's a space where you have to put your social security number, but in that situation you would put your agency's EIN number, so it's not like you're putting your own information out there. But if the agency is doing it, there can only be one person's name associated with each EIN number. So you should have a point person who's going to handle all of the notices of intent for the children that you're involved with. Okay, so you filed your notice of intent, you're waiting for your eligibility determination. You should be thinking about whether the public or private school option would be best for your child. If you're looking at the public school option, you'd want to contact the school district, get together your list of questions. The public school option is only available it's subject to the school's ability to provide the services that are required, because the public schools are bound by the child's IEP or 504 plan. In terms of the private school option, the website has a link of participating McKey eligible schools, and you can click on that and just start contacting the private schools individually with your questions. Sarah will talk a little more in detail about the things you want to be on the lookout for when you're speaking with the private schools, but two things. One, you want to look at the tuition, but also ask questions about any additional fees, book fees, or any other kind of hidden costs, because anything over the scholarship amount has to be paid by the child's parent. That said, a lot of the private schools will offer their own scholarships or help you find ways to make up the difference, but those are questions that should be asked up front, particularly with kids in the dependency system. The other thing to be on the lookout for are the deadlines that are inherent in the application process. And we can go to the next slide, thanks. Under McKey, because it's a funds transfer type of statute, all eligible children who apply will receive a scholarship. So it's not that not meeting a deadline would make you ineligible, but the way they set it up is when your notice of intent is filed, depending on when you do that, you might get your full scholarship amount, or it might be prorated. In other words, if you do it during a school year, which is not necessarily ideal, but sometimes with dependency that might be warranted. So for instance, to get 100% of the scholarship, you'd have to have your intent filed by July 3rd and have the child enrolled by August 2nd. And then it's prorated down to where you would only get 25% of the scholarship awarded if the intent's filed by January 31st. So if an intent is filed February 1st, it's going to apply to the following school year. You're out for that school year. Also, intents that are not used will expire on April 30th of that school year. You can simultaneously apply for the McKey Scholarship and the Gardiner Scholarship. You cannot be awarded both, but you can apply for both, but you really have to be on top of what's going on, because under the Gardiner Scholarship, it's kind of geared toward automatic funding, and the process gets rolling and you may not even know it. So if that happens and you're deciding, oh no, I really want McKey, it may have already kicked you out of the McKey process. So just be on the lookout for that. We would encourage you to just keep checking the website too, in case there's any change in deadlines or any other information. It's pretty user friendly and has a lot of information for parents. Okay, so let's say your child has received a McKey scholarship. How long does it last? It will last until the child graduates from high school or reaches age 22, whichever occurs first. If the child turns 22 in the middle of a school year, they can complete that school year as a McKey student. The scholarship will be forfeited if a student returns to the public school, unless the time in public school is for less than 30 days based on placement by or while in custody of the Department of Children and Families, and that's pretty relevant, of course, to our kids. But to keep the scholarship going, you don't need to do a new notice of intent every year. All you need to do is timely enroll for the following school year. Currently, that date is August 2nd to be enrolled for that school year, but again, that could change. I would encourage you to keep checking the website. A parent may also, while maintaining the same McKey eligibility, choose a different private school as long as they give notice. You don't need to reapply or anything like that in terms of the notice of intent. Of course, you'd have to apply to the other private school. A parent may also decide that the private school option isn't working and they want their child back in the public school. That can also be done with notice to the school district. But if they choose to go back to the public school and then later decide the private school option is good, they would have to start from scratch, do a new notice of intent, and reestablish their eligibility to go back under the private school option. Okay, so what else do you have to be aware of in terms of maintaining the eligibility of your student? They cannot be in DJJ commitment for more than 21 days. They can't be homeschooled. They can't be receiving any other state-sponsored scholarships, such as the Florida Tax Credit Scholarship or the Gardiner Scholarship that Sarah's going to talk about. They can't be enrolled in virtual courses except up to a maximum of 2 courses per school year. They allow that exception. And they can't be enrolled in the Florida School for the Deaf and Blind or be in a private tutoring program. So those are things to be aware of to maintain the eligibility and not forfeit the scholarship. Okay, so just the logistics of the scholarship payments, they're made in quarterly installments, and that's consistent with those deadlines in the prorated system we talked about. So on the 1st of September, November, February, and April, individual checks are made out to the parent but mailed to the private school, and the parent needs to go in and restrictively endorse for deposit in the school's account the check each quarter. The payment eligibility is based on the verification of continued enrollment and meeting the attendance requirements, and the website has an affidavit signature card that has to be completed by the parent in conjunction with restrictively endorsing the checks. Okay, another consideration, I mentioned earlier that this really needs to be a team approach, and the surrogate parent should be willing to work with, you know, everyone here. This is something that you really need to discuss in depth with the caregiver in particular. Transportation under the McKey program, if the public school option is chosen and the child is placed in a public school consistent with the school board's choice plan, the school district has to provide the transportation for the child. Any other public school choice or any private school choice, and it's the parent's responsibility to provide the transportation. So as you can imagine, you know, that could be a big factor in considering whether or not this would be a good option for your child and this, you know, the placement they're in. So just something to think about. McKey recently added a transition to work program for students ages 17 through 22. And it's a combination of academic instruction, work skills training, and a volunteer or paid work experience. Private schools participate in this program at their own discretion. If they want to participate, they need to submit a general program plan to the Office of Independent Education and Parental Choice, and then once that's established, they would need to submit a personalized plan for each child in the program. So just something to think about, you know, if you're working with older students. Okay, so you're in the program, you've got a McKey student. What if there's something you think isn't right, there's some type of violation of the statute or the rule, or what if someone files a complaint against you? There is a specific complaint process that's outlined in the statute. It begins by an initial complaint either through the toll-free hotline or through the website. That initial complaint just basically includes the complaining party's name, contact information, and some details about the situation. Then the Department of Education has to offer a formal complaint form that has to be completed and signed and submitted to the department within 30 days. And we've got all the statutory references there for you. At that point, there's been a formal complaint initiated, and the department will begin its inquiry. It will send out letters of inquiry to the alleged violator. It can be the parent, the private school, or the school district. They can also send out letters of inquiry to anyone else they think would have relevant information. And in that letter of inquiry, there will be a time, usually 15 days, that the party has to respond by. A failure to timely respond by a parent will result in the department's looking at whether or not that impacts the student's eligibility to continue in the program. If it's the private school that fails to timely respond, the department can proceed with noncompliance procedures. And if it's the school district's failure, the department will take any legal action to compel compliance and to ameliorate the effects of the violation. You should be aware that this process, this administrative process under the statute, is not subject to Chapter 120, which is the Administrative Procedures Act. The Administrative Procedures Act includes, due process protections and hearings and so on and so forth. You don't have that under this process, so you need to be aware of that. Okay, so the department's collected the responses to its initial letters of inquiry. It could request more information from any of the parties. It could conduct a site inspection or do an audit, depending on what the alleged violation is. If the department finds no violation occurred, it will inform all the parties that the inquiry will be closed. If a violation is found, similarly to not responding to a letter of inquiry from the department, if the parent is the violator, the department will determine whether or not the student's eligibility is affected to continue as a McKey student. By the private school, noncompliance procedures will be initiated, and by the school district, any legal action to compel compliance and to ameliorate the effects of the violation. At any point in this process, the department may refer an inquiry to its Office of Inspector General. Okay, so there's been a complaint, it's gone through the process, and say you were the party complaining and the department found no violation. You can agree with them and go on. Or this case that we've cited says that you can seek relief in the circuit court. I will tell you that under McKey there are only 2 reported cases, and they both involved matrix complaints, and as we talked about, the remedy there is very limited. It's only to correct the typographical or calculation error. So there's a dearth of case law on this, so if this happens, we would encourage you to be creative. As we said, and Sarah will go into a little more detail, but when you parentally place your child in a private school, you're really relinquishing a lot of your rights under the IDEA. It's unclear whether you might still have some type of cause of action under Section 504. We've found conflicting authority on that. But again, we would just encourage you to be creative and know that you do have the ability to seek relief in the circuit court. So at this point, Sarah will talk to you a little bit about the Gardiner scholarships.
So I'm going to talk to you a little bit about the Gardiner scholarships. The purpose of those scholarships is really to help the parent meet a child's individual educational needs. The Gardiner scholarships provide money for instructional services, including private school tuition and tangible items like technological devices or educational curricula for homeschooling or for schooling outside of the formal school setting. It's funded by private contributions that are held by the state, which then disperses those contributions to a scholarship funding organization. The scholarship funding organization then administers the program and is responsible for then transferring those funds to the parent upon the awarding of a scholarship. The scholarships are provided by private contributions, so they are limited. They're, with the McKey scholarship, a student who qualifies will receive it. The Gardiner scholarships are first come, first served until the funds are exhausted. To be eligible for a Gardiner scholarship, you must be a Florida resident, and the child must be turning 3 years old by September 1 of the school year for which you're seeking funds. And that funding can continue through grade 12. In addition to that, the student must have a qualifying disability and have an IEP or a diagnosed disability from a licensed physician or psychologist. The qualifying disabilities are very discreetly laid out, and as you can see, they include an autism spectrum disorder, cerebral palsy, Down syndrome, an intellectual disability, Phelan-McDermid syndrome, Prader-Willi syndrome, spina bifida, a high-risk kindergarten child, muscular dystrophy, or Williams syndrome. And all of those are further defined in section 393.063. And as you can see, most of them are very specific diagnoses. An intellectual disability is further defined, and it's generally a student who has a measured IQ at least 2 standard deviations below the mean with concurrent deficits in adaptive functioning. So that's about an IQ of 70. And then the adaptive functioning is also measured by standardized testing, and that looks at standards of personal independence and social responsibility as would be expected due to the child's age, cultural group, and community. So it's possible you could have a child who has an IQ of 70 but has the coping mechanisms and the adaptive skills that you're not seeing deficits or not seeing certain levels of deficits in how they function with their peers, how they function in the classroom. And in that situation, the child may be deemed not to qualify for the scholarship. And then if you look at the high-risk child, that's defined by statute as well, and that's a child aged 3 to 5 who fits one of 4 criteria. That's a developmental delay in cognition, language, or physical development, surviving infectious or traumatic illness associated with developmental delay. The child's parent or guardian has a developmental disability and requires assistance to meet the child's needs, or the child has a physical or genetic anomaly associated with developmental disability. Developmental delay is not itself defined in the statute, so if you have a child who's in this age range and doesn't and has a developmental delay in cognition, language, or physical development, you can make the case as to why the delay is significant enough to qualify this child under the statute. And then for the others, you'll have that diagnosis needs to be made by a professional, and so you'll have that in your paperwork going forward. The amount of the scholarship, in some ways, it's calculated based on the student's grade, the county in which they live, their individual level of need, and then the maximum amount equivalent to the base student allocation with matrix factor applied. As that's the same kind of matrix calculation that Laura was talking about with the McKey scholarship. It's very complicated, and what the statute actually provides further is that for all students, the matrix is calculated to be 253, which equalizes to a level 3 services. If you want a more individualized determination for your child, you can seek it, but you're also stuck with what that result is. So if you think a child's going to qualify for a higher level of service and you request the individual evaluation and it comes up with a factor of lower than the 253, the scholarship is going to be based on the lower level. So that's just something to do a little bit of research and make sure before you request that evaluation that you're confident in what the results are going to be. The average scholarship for 2016 was $10,000. And one of the scholarship funding organizations, I believe it's Step Up for Children, on their website they actually have a printout of each county and each grade and how much the scholarship would be for that child. And they all range from slightly over $9,000 a year to slightly over $10,000 a year. So the scholarship funding organization, we have 2 of them in Florida, as I just said, Sub Up for Students and AAA, which is Academic Achievement Accessible. Excuse me. And both of them are on the Department of Education website under the Gardiner Scholarship links. So the way that the funding works for these is when a parent has applied for a scholarship with the Department of Education, through the website, the SFO receives that and they request funds from the department. The department then will transfer those funds to the SFO once the SFO has established and created an account for that particular child. The funds include the awarded amount plus any interest that has accrued, but there is a 10% fee essentially that goes to the SFO. So the amount the student gets is actually 90% of the awarded scholarship amount. The parent then secures the services or the tuition or whatever the approved expense is and submits them for reimbursement, and then the SFO devises its own system of payment, whether through a funds transfer or through a debit card, to reimburse the parent for those expenses. The application is actually very easy. It's available on the SFO websites. In general, they ask that you apply the February before the school year in which your child wants to participate. However, it's a pretty fluid program, and as you'll see, much like the McKey Scholarship, they have later deadlines for which you can receive prorated amounts for your scholarships. All the parent really needs to do is create a request that creates a written record and demonstrates the date of receipt of the request by the SFO. So that can be by email. The SFOs have the links right on their websites. It's very easy to get to and to do. And here's just the links for how to get there from the Department of Education website. As I said earlier, the funds are awarded on a first-come, first-served basis. There is a priority for renewal students. So students who have previously received funds can continue to receive the same benefits they've been receiving. Students who have applied on prior years, but there weren't insufficient funds and they got put on a wait list. Newly approved applicants, and then late filed applicants. And here are the deadlines for prorated funds. And so you can see while they ask that the applications be submitted February of the year before, as long as you get them in by September 1, you'll still receive 100% of the awarded amount. The neat thing about this program is that the authorized uses for program funds is very broad. It's really anything that will assist the child in meeting their educational goals. So you can have instructional materials like digital services, assistive technology. You know, if their insurance won't cover a communication board, and that would be appropriate, you could use these kinds of funds to purchase that. If you have a child who is homeschooled, you can get curriculum for that. You can get services like ABA therapy, speech language therapy, occupational physical therapy, and you don't have to use the full amount for a service. So if you purchased curriculum for $7,000 and you had $2,000 left over, you can apply it to something else that would be an approved expense. So you can get tuition for private school, home education programs. You can get private tutors with the Gardiner Scholarship. You can enroll in some virtual programs, although not public school virtual programs. They need to be private entities. Private summer education programs and private after-school education programs. You can get fees for standardized tests, and you can even have contributions made to prepaid college, Florida college prepaid programs. And that's what a lot of people will do with their leftover funds, is they'll use them for what they need right now and then invest it for college. You can sometimes get contracted services through a public school for certain kinds of classes, and as long as they're on a contracted fee-for basis, that you can use these funds for that. There's a little bit of an error here on the program funds. VPK is not an eligible expense, it's free, but it is because it's, the statute wording on that is kind of ambiguous, so I just want to make that clear that voluntary pre-kindergarten is not an authorized use of program funds. So I apologize for that. These scholarships last for the school year, and they do, unlike the McKey, they do have to be renewed every year, and the SFOs determine what their renewal process is. It's not a new application. You just have to submit some paperwork that they determine to establish your continuing eligibility for the program. If the student enrolls in public school, graduates, or reaches age 22, they're no longer eligible for the funds. So again, to maintain your eligibility, you need to not be enrolled in a public school, a charter school, or a virtual education program. But again, the approved contracted services can be okay. You cannot be enrolled in a DJJ school, and you cannot receive another Florida scholarship. And then you also have to meet the mandatory attendance requirements that would apply to a public or a private school student. To renew your eligibility, as I said, you will annually submit your agreement with the SFO, and you need a notarized sworn compliance statement that indicates that the child has continued to maintain eligibility. The grievance procedure is similar to that for the McKey Scholarship. You can initiate a grievance complaint by contacting the Department of Education, either by phone or through the Florida School Choice website. Once that initial contact has been made, the department is required to offer a formal complaint form. You don't have to use the complaint form for the Gardiner Scholarship, but you do still have to file some sort of written complaint with a signature, and you have to allege a specific violation of law or rule by the parent, the private school, the SFO, or the school district. With the way that this particular scholarship works, unless you're having an issue with getting an IEP at the beginning before you then choose to move to the scholarship, you may not have a lot of interaction with the school district. But the parent, the private school, if you choose one in the SFO, will always be involved. The department's required to conduct an inquiry upon receiving the complaint, and then it can make a referral out to the appropriate agency for investigation. If it determines the complaint is legally sufficient, let me back up. Before it sends it out, it will make a determination if the complaint is legally sufficient. And to be legally sufficient, you have to contain ultimate facts showing a violation of the law, or a rule that applies to the program. The department may ask you or may ask any of the parties for additional information related to the complaint. The complainant of individual or entity will receive a letter of inquiry and be given 15 days to respond. Failure to respond, the consequences are similar to that for the McKey. The SFO, if a parent doesn't respond to a letter of inquiry, the SFO can use that to reconsider and even to deny the child continuing eligibility for the program. Non-compliance procedures will be initiated with respect to the private school or the SFO if they're not compliant, or if they don't respond. And then the school district, the commissioner can take any legal action to compel compliance and to ameliorate the effects of the violation. So you have somewhat of a greater remedy as with the school district, but in the Gardiner Scholarship, they're just not quite as involved. Possible outcomes of the complaint will be that the complaint would be closed if it fails to allege a violation. The department can continue to request information it needs until it has enough information to resolve the complaint, or it can determine a violation occurred. The department must notify the complainant of the final result. And then again, if the violation occurred, non-compliance procedures can be initiated. The scholarship can be discontinued for that child, or other sorts of ameliorative action can be taken against the offending party. And like the McKey Scholarship, the DOE inquiry under the Gardiner Scholarship is not subject to the APA. So you don't have a due process right to a hearing on the violation you've alleged within the administrative procedures. This scholarship has never been challenged in Florida law, as far as I can tell, in a circuit court. But I see no reason that upon exhausting the administrative remedies provided in the statute, that you couldn't also take it to circuit court if you needed to. So that kind of sums up the Gardiner Scholarship. There is a brochure at the back of the room next to the water from Step Up for Students, which actually has a table downstairs if you have more questions you'd like to ask them. And it has actually a comparison of the Gardiner Scholarship with the Florida Tax Credit Scholarship, which we didn't talk about, but it does have some helpful information in a flow chart for how you would access the Gardiner Scholarship. So as Laura alluded to earlier, with both of these scholarships, they have the potential to be of great benefit to some of our students who are struggling in the public school system, but they're not without their drawbacks as well. And the onus is really on the parent or the person seeking the non-public school placement to make sure they have all of the information necessary to make a fully informed decision. You want to ask about any hidden costs or fees, as Laura said, book fees, activity fees, whatever it might be, because once the scholarship amounts are exhausted, the onus is on the parent to pay for the education. With private schools, they're regulated differently than public schools, so you want to look at teacher qualifications in the school. Is that teacher certified to teach? You know, what is that teacher's background? Do they have the knowledge to be teaching your student? And then because private schools and, well, students outside of the public school curriculum aren't required to do the same sorts of standardized testing. So, you know, you want to make sure that you understand or that you have some knowledge about the educational benefits actually being conferred to the students. Are they learning things? Are they progressing in a way that we would expect them to progress over the course of the year? And they said the non-public school systems are not regulated by the Department of Education. The department has really a very limited role in the event that you have concerns about how a private school is conducting itself. They can do random site visits and things like that, but it's a very limited basis. And it's a buyer's market. The private schools, they want your tuition dollars. So just make sure that what they tell you they can offer you, they really can provide. And then as we talked about the possible waiver of rights under the IDEA, when a parent exercises school choice and places a student in a non-public school setting, you no longer have an individual right to special education and related services. There's very few due process protections, and that will come into play for some of your students who have more significant behavioral issues. When you're looking at things like suspension and expulsion, the public school provides a very detailed due process to accomplish that. With a private school, you're kind of stuck with whatever this private school's process is, and that can have effects later if your student is expelled and you're trying to get them back into public school. And then we've just listed here two, this is a very timely topic. So there's been a lot of discussion lately about different school voucher programs. So the New York Times recently had an article that looked at a couple of different states' programs, including Arizona's, and speaks about the McKey scholarship. And then the Council of Parent Attorneys and Advocates had a really good article comparing different states' voucher programs and what the concerns are that they have. And a lot of that would be relevant to, for us to look at as well as child advocates. So we're going to shift it over to a little bit of group discussion. Wendy's got a microphone and some chocolate, so please participate. But if you have any questions, or if you have a child that you think might benefit from one of these programs, let's talk about it and see if we can kind of figure out what makes sense and how maybe to pursue that further. So I'll open it up.
We have any general questions first?
I have a question. I thought you said, I heard you say that eligibility for the Gardiner could be based on the parent having developmental delay?
Yes. So for a high-risk child who is age 3 to 5, so not in school yet, but eligible for a preschool type program, if they have a parent or guardian with a developmental disability and that parent requires assistance to meet the child's needs, that is a qualifying disability. But the child also has to have, the child also has to meet the other criteria. So the IEP or the diagnosed disability themselves, but it doesn't have to be, the child's diagnosed disability doesn't have to be one on that list. So you could have a child with maybe a vision impairment that wouldn't qualify for Gardiner otherwise, but if you have a parent who has their own developmental disability and can't meet the child's needs, that would qualify the child under both prongs.
So I have a parent who just misses qualification for APD. There's
Okay.
an IQ cutoff and she's like 1 point above.
Mm-hmm.
And she has a child who has a vision impairment.
Okay.
So that would work for Gardiner,
Yes.
as long as the child is still between 3 and 5.
As long as the child is still between 3 and 5. The developmental disability, quote unquote, is not defined in the statute as applies to the parent. So that might be an issue of discussion if they don't qualify for APD services. But if they have a diagnosis from a licensed, if the parent has a diagnosis from a licensed psychologist or physician, I would think that there would definitely be a basis to explore that. I think there was a question back there.
I have a practical question. Why would we want to apply for a McKey scholarship for a child and then choose for that child to go to a public school in the same district, as opposed to just using the IDEA and the IEP team to find the appropriate school setting within the district?
Go ahead, Laura.
That's a great question. Basically, it means you can't get there through the IEP team.
Oh, yeah. So yeah, ideally you could get there through the IEP team, but this gives you another avenue to get there, and it also lets you look at the adjacent school district. Does that answer your question, or?
So you can go to an adjacent school district?
Yes, under McKay. Yes. Do we have other questions? Yes, we have one.
Hi. I had a case where I was working with the Gardiner Scholarship last year, and my question is, so I had a parent wanting to put them in a private school, but the kid also needed speech therapy, all that stuff. And he had to take the child to the speech therapist every other day. I'm just trying to think of the practical advantage of doing the Gardiner Scholarship when you're going to be required to bring the child to all the therapies, unless you find a very specialized school that just deals with autistic kids. But we don't have that in our area.
So if I'm understanding your question correctly, I think that's really an individual determination to be made case by case. For some students, being in the private school is really kind of the primary school placement. And then if you have the other therapies that you need that require transportation outside of the school too, for a certain family that might be worth it. For other families, it might not. Would you like to add something?
I just wanted to make a comment that, like, you have it is very specific to the child. Because, like, a lot of public schools are like big factory schools. And you have children, and they, of course, they have the services. But that doesn't mean that child can adapt to that school, even with the services. A child on the autism spectrum might just not be able to adapt. And so and you have to be very careful in exploring the alternative private school, because there are private schools out there that do a better job, but it's all specific to the people that are running that school. And the irony is, it's the same thing about the public school. You have, I know some public schools, because one of my children has autism, so you network with other parents, and you find out about which public school has a better program, and it's all people-driven. It's not program-driven. So that's one of the reasons why you might, be willing to drive your kid to the school, pick your kid up from the school, take the kid to special services, only because you're tailoring the services to the child, even though it's, for a parent, it could be a big inconvenience.
That's an excellent point about it being people-driven, not program-driven. And so when we look at the team approach and the legwork of the surrogate parent and whatnot, it's not just saying what services do you have, but I would say it's actually meeting the people who are going to be providing those services, and go with your gut. Sometimes that's what you need to do. So good point. Thank you.
I had a comment as well to add on to that. We had the same experience. Sometimes it's about the environment that you can get provided to match to the child, to give them the environment that they can flourish in. But some of your school districts may do push-in services into the private school where the private school allows that. My son with autism received speech therapy at private school under McKay. So check with your school district to see if they're supporting the children who are there under the McKay scholarship with services provided by the school district on the private school property.
Thank you.
Any other questions, or any kids you want to talk about who you think may or may not fit into one of these programs?
Yeah, we didn't want to just create hypotheticals, because we know you're all dealing with real students. So if you have any student that comes to mind.
I don't have a student that comes to mind, but I just wanted to mention one of the biggest problems that I see is that for most of the children we deal with that have special needs, they're also the ones that wind up having multiple placements. So one of the big difficulties is, and I've seen it where we've had, the best solution is when you have a relative caregiver or a non-relative caregiver who has a real big interest, and there's stability, and they're able to find a private school that meets the child's needs, and they get the McKay scholarship. That works. But for children in foster care, it seems the frustration is they're constantly moving around, and so it almost like takes this option out of the, out of the picture for these
Right.
kinds of kids.
And that, I mean, that is definitely a consideration. You need to look at your case, where your case is, where your child is placed, you know, kind of what, you know, when cases come in and you get familiar with them, often you have a sense of which way they're going to go or what you think is the most likely outcome. And, you know, part of your permanency planning can be, you know, we're getting this child in this placement, now let's look at school options. The step up for students, they're about a week turnaround for scholarship approval. So that can get in place quickly. And the McKey Scholarship and the Gardiner Scholarship can move with the child. So if you, you know, are lucky enough to be able to have private school placements, which with our kids, that's probably mostly what we're going to be talking about. You know, in each location, you might be able to continue it without too much trouble. But I mean, that is a drawback for our kids, is that they're not necessarily going to be stable enough to always take advantage in placement situations to fully take advantage of these scholarships. But for your kids who are, they're there. We just want it, you know, it is an option and something to definitely think about.
I think we had here.
I have an 8-year-old boy who is diagnosed with epilepsy and also oppositional defiant disorder. Would he fall into any of these categories?
Okay, would he?
What do you think?
I did not see
Anybody have
epilepsy
any
on the
thoughts?
list.
Okay.
Right, so epilepsy is not one of the qualifying diagnoses for the Gardiner Scholarship. So he would not be eligible for that unless there was a concurrent intellectual disability, or he was a child 3 to 5 who maybe fell under, you know, his parents have disabilities as well. But he would certainly be eligible for the McKey Scholarship once he was eligible. You said he was 8?
Yes.
So he would be eligible for the McKey Scholarship. Yes.
So as a follow-up question to the gentleman in the front, most of our kids are in foster care and moving from place to place. So if they were to receive one of these 2 scholarships and went into private care, would they still be under the protections of the ESEA and the Every Student Succeeds Act, so that they would have to be provided transportation to their home school? Or would they be removed from that? It's still federally funded, right? It's just not a public school anymore.
Well, if they were in the private school to begin with, that wouldn't be a public school to start with. So the school district isn't going to be responsible for transportation the way they would be for a public school move. Am I understanding your question correctly?
Right.
So I think the answer is, once you've removed the child from the public school, you know, federal protections just haven't completely been litigated, but they appear to not apply because you've exercised the choice to take the child out of the public school setting. And so I think it's going to be harder to get transportation in that instance. There are is it under the Gardiner? Mm-hmm. Under the Gardiner, there are some smaller scholarships for transportation, which you might be eligible for in that instance, but you're not going to be eligible for that if you're receiving the McKey to go to the private school in the first place. But if you've got a foster parent or who's a relative or who has some connection to a private school that wants to take the child there, and they're not otherwise receiving a scholarship, they could be eligible for some tuition assistance or for some transportation assistance for that as well. And I think those are about $500. Any other questions?
If we could, let's take Janet's 8-year-old with epilepsy and oppositional defiant disorder, and let's just kind of go through and pretend you're the educational surrogate, you're working in the team to make a determination whether or if either of these programs might be beneficial. What kinds of questions are you going to be asking? Who are you going to be talking to? What considerations are you looking at? Just generally off the top of your head.
I mean, it might be off base, but I'd be wanting to, I would assume the child has a 504 plan? I mean,
Right, let's assume
yeah,
that.
I would
Mhm.
assume the child has a 504 plan, so I'd want to look at the 504 plan.
Okay, great, good
Wanna
place to
review
start.
it. And I would
Do you
also
wanna do
be
the flip
wanting
chart,
to
or-
talk to his, the team, the education team that's
Mhm.
working with, like, the teachers, any guidance counselors, whoever's working with that child.
Great, okay, so you want to start with the plan that's in place and the providers that are currently working with the child to get a good idea of where we are right now. Terrific, okay, that's a great place to start. Then what? Okay, one of the things we talked about was looking at public or private school option and the potential drawback of the private school option in terms of relinquishing the federal rights and due process rights and whatnot. So I think one of the things you might want to think about are, and this child has oppositional defiant disorder. Is this child likely to have some serious behavioral issues in the classroom? Yes, this child is. Okay, so you need to think that through, at least when you're talking to private schools. Do you serve any other children with this disorder? Yes.
I'm sorry, I have another question, because
Okay.
a child with oppositional defiance disorder,
Mm-hmm.
I'd want to look at the evaluation that reached that conclusion.
Okay.
Was this done through a psychiatrist? Was this done through a psychologist?
Okay.
And, because one of the things about oppositional defiance disorder is that, from my experience, I'm working my caseload, that it's a condition that has to be addressed with both the caregivers have to have training in how to deal with the child, and of course, you also have to have the child, finding out what buttons to push. I could take the book out. I have a book on, it's called Strong-Willed Children,
Oh, okay.
and setting limits. And the thing is you've got to really know what this oppositional defiance disorder, what
Okay.
it's all about.
Okay.
Because you may, before you want to put them in a private school or any private education, like you say, are they going to be equipped to deal with this kind of child?
Right.
I mean, not saying the public schools are like the great answer. It all comes down to, does the educators know how to deal with this kind of child? Public schools will sometimes come up with plans on how to deal with a child with this this kind of disorder, and that's an advantage with the public school. But you could, you do research to see if there are private schools that, in the area where this child resides, that would be able to understand what oppositional defiance disorder is.
Right.
Because if they don't understand it, they're definitely not going to be able to deal with it.
Right, right. And I like what you said, particularly not just we're starting with where the child is right now and what their service plan is and what their needs are, but even delving into that a little bit further into the background. How did we reach that diagnosis? Like you said, and this all shows that there's a lot of work that goes into thinking this through. Did we have another comment?
Just real quickly as well. Oftentimes, ODD is a problem, not ODD. It is a post-traumatic stress disorder caused by fetal alcohol or fetal drug exposure.
Okay.
And we've been using a neuropsychologist, not infrequently, to do diagnoses for us, and he also comes out with the educational information as well. It will be included in the formation of an IEP or 504 plan.
Okay.
Having that information would spring-load this automatically for you. So if you have the 8-year-old with ODD, they probably need to be seen by a neuropsychologist to determine if they have some sort of developmental delay or they have actual brain damage caused by fetal alcohol or drug exposure.
Okay. Great. So even further evaluation from this point. Great. Yeah, this is fantastic. You guys are all on the ball. What other thoughts when we're thinking about our 8-year-old here? We're looking at currently where they are. We're delving into how they got where they are, maybe even requesting additional evaluations. What else do we want to look at?
Well, I think think going back to what I touched on earlier, I think you have to research the schools in the area. Because you have to research the schools in the area, both the public as well as the private schools. Because it's not easy, and it's very difficult for a circuit parent to do this. But, you know, you may find that the public school that this child, there may be a public school in that district that's actually will meet the needs of that child and might be better than any private school.
Absolutely.
And then there are private schools that will have a certain limited amount of services that will be suitable for that child. But you have to really look into it and ask questions. Because one of the things you got to be careful of is you'll have a school that will say, like you said, or, you know, in the slide, they want your money. So they'll say, oh yeah, we can handle this, we can do this, we can do that. Well, I don't know how you do it, but you might want to talk to parents. You know, is there any parents with any other children with, you know, McKey scholarship or Gardiner scholarship that I can talk to find out, are they satisfied with the school's services?
Right. Yeah, excellent point. You don't want to just take their word for it. Yes, we can provide those services because they're not bound by what they say. So you'd be out of luck. So absolutely.
Have you ever seen either of these scholarships provide for residential education, education placement, where a child needs consistency all throughout their day, and not just through a therapeutic foster home, but perhaps in an educational?
We have not. Yeah, we have not actually seen that. We actually were discussing that yesterday.
Is it possible?
We think so. I mean, again, it's going to be, it would have to be Gardiner for this, not McKey. But it would be based on the SFO, and so I would recommend talking directly to, and I would talk to both SFOs, the scholarship funding organizations. Like we said, there is information on the Step Up for Students, and then on the website there's the AAA. That's something I would bring up, you know, maybe like the private tutoring for that student in residential care. Yeah, good question. I don't know how we are on time. Do we still have time?
5 more minutes.
Okay. What about talking to the child? You know, just kind of, what do you like about school? What do you not like about school? You know, just kind of, you know, get a feel for where, you know, depending on their age and their, you know, ability, but something you might want to do.
I think that's a good point. What you really also want to do is see if you can get the child into a buy-in. You know, we're looking at certain schools for you. And I think, in my opinion, you have to look at the end point. Where is this child going to get its education? And then say to yourself, okay, do I need a scholarship in order to achieve that? And so you find out what would best suit the child's needs, and then you back up and you say, okay, a McKey scholarship might be a good program if you can find the right school. I think the Gardiner scholarship, the advantage is that maybe you might be able to get some additional services that you can't get through the McKey.
Right, correct, yes.
And also, this is a child with epilepsy, so we need to make sure the schools can meet their medical needs as well. Is there somebody on staff that can respond if the child just, oh, I'm sorry.
Sorry. I'll come up here. Reach.
You know, to remember this child has epilepsy. And so we need to make sure that the school has the capacity to respond with in a medical emergency. Do they have someone who knows how to handle a seizure? Do we need to provide training before the student goes in? Are they willing to accept that training? You really need to look at all of the child's needs and not just focus on maybe the specific reason you're looking at that school, which might be the behavioral issues. So just want to throw that out there. Anything else? Any questions? Any last parting thoughts or comments? Well, thanks for your participation.
Yeah, you've all been wonderful. Thank you.